मैंने आज फास्ट ट्रैक कोर्ट के लिए विभागों को निर्देश दिए थे। फास्ट ट्रैक कोर्ट और कठोर सजा के प्रावधान के साथ का ये मुसद्दा कैबिनेट के साथियों के सुझाव के बाद उसका अंतिम रूप दिया जाएगा। जल्द से जल्द उस बिल को सदन में पारित कराने का प्रयास किया जाएगा।
Why our Prime Minister had to send a message at 12 in the night? What are the tough measures that are going to bring down the paper leaks? And most importantly, why the previous laws have failed and what would be done right to correct them? Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to understand from scratch that what do these strict actions mean, what the government is trying to bring in to change the setup of paper leakings across the country, and most importantly, if these things will work. If they are not working, then what exactly is to be done? So when we are looking at today's situation, what has happened last night is that our Prime Minister has sent a video message in which he has clearly told that today will be the day where stringent, strict actions will be taken up. He announced about fast track courts day before yesterday, and now he is saying that the government will come into the picture. The cabinet is going to sit today and take strict action. Now, amidst the strict action that have been talked about, cabinet has not announced anything as of now, but there are two clear things on the card. What are these two clear things which are present in front of us? The first thing that is present in front of us is the fast track courts that have been announced just yesterday. I have covered it in detail that what exactly are they, how they are functioning, how they are different from regular courts. You can go and watch that video. Now, when we are looking at fast track courts, as soon as the announcement was made and how committed the government is, that immediately we saw announcement coming from different high courts that the fast track courts have already been designated, be it Delhi High Court, Mumbai High Court and others. So as of now, what we are looking at that the government is already in a power mode to ensure that the promise that they have made in terms of fast track court, that is being delivered in reality, in total honesty. And all these fast track courts will be focusing specifically towards the cases of Public Examination Unfair Means Act of 2024. And amidst this, we are also seeing that how Education Ministry is also seeing a jig. Amidst this, the demand is the resignation of Education Minister, but as of now, the Education Secretary has been shifted out. So this also shows that government has not only been focusing on fast track state courts, but at the same time they are also looking into accountability from their very end. Apart from that, government is also focusing on strengthening the law which exists at the same time. So when we are looking at this scenario, finally after 26 days when Sonam Wangchuk has broken his fast, the government has come into the picture and government is committing to the cause, at least trying to go for damage repair full front. In this context, the second thing that the government has proposed is strengthening of the law. Now the question arises here that why exactly is this needed? We already got this law just 2 years back, Public Examination Prevention of Unfair Means, and this was done when we saw multiple paper leaks in 2024. Just before that, in 1 year, we saw 51 paper leaks which were reported, affecting more than 50 lakhs of candidates, which had economic impact in terms of recruitment, loss of productivity, loss of capital, and so much more. So this came into the picture, but why is this not functioning? And when we are looking about this, this is what exactly government is trying to change. Government is saying that we have the law, what we are going to do is make it stricter. Now, how are they going to make it strict? They are going to increase the jail term. Now, before I answer this, I need to know from your side, do you think just increasing the jail term is that going to solve the problem? Now in this context, what government is saying? Government is saying we will bring an amendment, and this amendment will strengthen the law that exists to prevent the paper leaks. The amendment will be focusing not just on fast track courts, but there will be also increase in the jail term for the offenders. So initially the jail term was only 3 years. Now it might be pushed to 10 years. Now the reason this will not be solving the problem, because if we are looking at the cases that have occurred between 2002 to 2025, what we see is the fact that cases are above and beyond 50, but the convictions that have happened are only 2. And this is where we find the problem. No matter how much jail term you keep, if the person is not getting convicted, if the root of the problem is not being understood or cracked, then this is absolutely a facade. And in this context, the biggest thing needs to be understood, that is the fact that why conviction rates in our country till date are so low. The first reason, of course, here is the weak investigation. Let me give you an example here. In 2024, CBI proposed a closure report in the Supreme Court for the UGC NET of 2024. Now, in this context, the court had to rebuke CBI that how come you are lacking evidence when the evidence was actually present. So, the weak investigation, limited evidences, and so many other causes such as slow judicial process, filing the closure report prematurely, easy bail under the given criminal provisions, and more. So the incidents I was telling you about was of Delhi High Court, and this is something that has been prevalent all across the cases that I have been talking about. The numbers might be big, the conviction is close to 0. So the problem, the core issue is not just tightening the law which ensures that there are limited leaks, but it is also to ensure that the offenders are successfully convicted. And if that does not happen, the amendment of the law that government is talking about is not going to serve the purpose. Now the question here is, where is this whole system failing for us? Now let us look at the most recent example because of which all of this country has finally awakened and is looking at that what exactly is flawed with our education system. We are looking at the timeline when this NEET paper leak unfolded. Now when we are looking at this timeline, we are going to understand that medical aspirants were involved, parents were involved, a huge systematic racket was involved in the tip of and what not. But the involvement was not just merely of the people, and it is not just something that unfolded between these given dates. It is something that was planned well before. People were aware of the consequences and they knew how light our system goes in terms of conviction. They were enabled by technology, they were facilitated by digital means, and so much more. And this is exactly where our systems have been failing, because we have 3 major clear reasons for which our things are not working out. First, our offenders are using the technology way better. They are getting way advanced as compared to the systems that need to catch them. So what we are seeing, that crime has modernized faster than enforcement. Old times you were looking at fax, now you are looking at Bluetooth devices, remote access software, you are looking at printing firms, you are looking at telegram, logistic companies, and so much more. So here we get to see one clear outline. But when we are talking about these offenders being recognized, they are complemented in their situation by weak investigation, which I have already pointed out, and we also have to add the layer of outdated legal framework. If the new amendment does not address this problem of outdated legal framework, this amendment is pretty much useless. It will keep the law as it was. Because most cases which are booked under BNS, which was previously IPC, they are just like cheating, forgery, criminal conspiracy. The problem with this legal framework is this defines the offense as an ordinary offense, making for people to get bail easily, making the deterrence way lesser. And this has created a threefold shield in which offenders are capable better, they are to an extent protected better, and then they are let gone off in an easier way. And this is the exact reason that this whole system has rotten over years and it has not been identified. So the question here is, what will this new amendment to the Act do? The Act already promises a lot. It promises punishment, it promises jail time, it understands the importance of property because it attaches property when we are looking at convicted people. So it is trying to address a lot, but it is not applicable until and unless the conviction will happen. Where will the conviction happen? Conviction will happen in fast track courts. That is why fast track courts have been brought in the picture. But fast track courts do have their own challenges. I have discussed about them in yesterday's video. I have already mentioned it to you. Fast track courts can actually play a real role in creating some deterrence, especially when we are looking at these syndicated crimes related to paper leaks. How they can do that? When we are looking at fast track courts, we are ensuring that there is not only quicker hearings, there is also proper judgment, lesser adjournment and faster witness examination. All of this leading to higher deterrence in itself. That means the offenders will have lesser probability to be saved. But at the same time, you have to understand that the problem were layered, so the solution also needs to come in layered, where law needs to be combined with investigation, and when that is facilitated by court well in time, that is only when we will be able to create deterrence and enough deterrence that at least offenders think about consequences. So in this context, what government is addressing right now is only two of the dimensions. The focus also needs to shift not just to the third dimension, but what better can be done in terms of law and also courts, because they also have their own present challenges. Because if this does not happen, it will be exactly like what happened to Railway Group D paper leak in 2006. Because as of now, that particular case in 2026 has only reached the witness stage. But when we are putting so much on fast track courts, we still have to understand that alone fast track court cannot be the panache to whole of this situation. We need to look into how we can enhance institutional accountability, because officials, be it part of NTA or other examination authorities, they are the ones which have been involved in leaks. There needs to be oversight not just across the institution but internally as well. That is when we need to bring in technology into the picture so as to secure the examination process. We are not just talking about computer-based tests, we are looking at end-to-end digital tracking, GPS monitoring, secure printing system, tamper-proof logistics. And that is when we also need to focus on better investigation, where we have to get a hand on the technology in real time, be it in terms of digital evidence, cyber forensics and financial investigation. That is only and only if government considers all of this along with speedy trials, we might have some respite, we might get some solutions. Otherwise, the coming days are going to be just like this, with a newer amendment to the law, with fast track courts but no conclusion, no convictions, and also a lot of impact, especially when we are talking about the morale of the youth and also the economic impact that the government, the youth and the country is already bearing. Now, what are your thoughts on this? Let me know in the comment section. We will wait to see that what cabinet exactly announced in detail. We will be discussing that as well. That was all for today. Thank you so much.